These folks took it all the way to the Supreme Court. The Supreme Court said, oh, yeah, they can wear the armbands as long as it's not substantially disruptive.
Welcome to Queen City News Plus. I'm Brian Blakely.
And I'm Chief Legal Analyst Khalif Rhodes.
Khalif, always good to see you today. Hey, court is in session, but school may not be. Today we're talking about the U.S. Supreme Court declined to hear a student's challenge on free speech on the grounds of a Massachusetts public school decision to bar him from wearing a T-shirt reading "There are only two genders" due to concern about the message's effect on transgender and other pupils. What say you?
Brian, when you said school's out, I'm thinking you're talking about school's out for the summer. My kids cannot wait to get out. I know your folks are getting out already. So I'm like, well, maybe it's going there, but you're talking about this case. So a couple things. I remember these types of cases in law school when you're talking about constitutional law, First Amendment cases, speech. I say it a number of times, and I say it because the law says it, that the government can chill your speech. That means stop your speech, slow it down, limit your speech only in a couple of places. Like we talk about speech is free, and it is, right? You're able to say what you want most of the time. But in public places and in places where the government has control of your speech, they only have an ability to limit it if they can do a couple of things. Most of the time, if it's narrowly tailored and there's a compelling public interest, you know what? We want to prevent this type of incident from happening, and it has to be, I should say, content neutral. If we're trying to say that we want to narrowly and freeze your speech or chill your speech, and it's content specific, like in this situation where it's this kid's shirt, then you have to do a couple of things. Outside of school, typically it's compelling interest, narrowly tailored. But in a school setting, the courts have said for a number of years, based on this Tinker case from the 60s, that you have to be able to show that you can do the speech. You can do whatever your speech is as long as it's not going to be a substantial disruption to the school setting. And that's been the law since the 60s. In this court, the lower court agreed with that ruling based on Tinker. The Court of Appeals agreed with that ruling based on Tinker. And the Supreme Court declined to hear it because they couldn't get 4 justices to make a determination if this was something that they needed to do. But that substantially disruption, that's major. I mean, think about what was happening during that time, Brian. Talking about Vietnam War. These kids were wearing, in the Tinker case, black armbands because they were showing their support for the not going to the war. The school didn't want them to wear the armbands. These folks took it all the way to the Supreme Court. The Supreme Court said, oh, yeah, they can wear the armbands as long as it's not substantially disruptive. And so the lower courts with this case, with this T-shirt case, said, hey, in this era, you wear a T-shirt like this, yeah, it's probably going to be substantially disruptive because you're going to have folks that are transgender. You're going to have folks that are non-binary. You're going to have a lot of kids that may be disrupted from going through their day-to-day learning activities. And the court decided that that's not something that we want to have happen in our school.
Well, and one of the things, too, and I think the lawyers for the case for the 7th grade students, what he was trying to do and trying to convey here was what was called a meaningful conversation when it comes to gender and identifying gender and transgender, and also whether it's binary and those kind of issues.
The problem with those types of statements, Brian, is that the court can always limit content neutral, right? Not content specific, but content neutral. And they can say time, place, and manner. I'm going to limit your ability to have these kind of conversations that you want to have, but you can't have it here. You can have it outside. You can have it at your house. You can have it on the street, but you can't have it at the school. So we already have that established with most speech, time, place, and manner when we're talking about places that are not school. And I think if we didn't have Tinker, the court would say that look, you can have this conversation. You just can't have it right here. But now, even if we're saying you can have conversations about politics or you can do things that engage thought because you want that to happen at school, but you can't do things that may be deemed as hateful, that may be hurtful or like Tinker said, that will be substantially disruptive from what the idea, the purpose of school is. School folks are supposed to be there attempting to learn. So if someone can't even come into the building to learn because they're now feeling like they're being hated, that's what we don't want to have happen. And so that's why Tinker was ruled that way. And that's why the lower courts in the Court of Appeals ruled that same manner. But what I will tell you is I often say that dissents are telling. So you can see that who wanted to hear this case. Justice Thomas wanted to hear this case. Justice Alito, he wrote a 14-page dissent saying that he would have loved for the court to break down and hear this case. And so I always mention that facts, timing in a court make for things that you read about in the law books. And this would have been a case that probably would have made its way to some law student's essay or a multiple choice exam just based on the facts.
Yeah, I want to go ahead and read that a dissent here by conservative Justice Samuel Alito in this case, that he called the First Circuit Court ruling flawed. Quote, as this case makes clear, some lower courts are confused at how to manage the tension between students' rights and schools' obligations. And he also, Alito wrote, joined by the fellow conservative Clarence Thomas, our nation's students, teachers, and administrators deserve clarity on this critically important question.
And I'd agree with him for a couple of things. That most of the time when the Supreme Court will grant cert, that's the actual opportunity to hear the case. When you get 4 more justices agree to hear it, it's when you have a couple things: a constitutional question. So speech is a constitutional question. Check that box. But then it's when you also have conflicting reports from different rulings from different courts. And so in this situation, I would agree with Justice Alito. While I don't agree with the way that he would want to rule this case, I do think that this is a case that the court should give clarity on, because I remember there's this be happy, not gay. The courts allowed that to be worn in school, but this homosexuality is shameful. The courts didn't allow that to be worn. And so those are situations where you have, it seems like, conflicting rules over the last 20 years from 2 examples of 2 shirts that different schools allowed in or out, and then courts ruled different manners, which you would think both of those should have been allowed in or should not have been allowed in. Who knows? But in this situation, the courts have given conflicting rulings. That's ideally when you would want the Supreme Court, not an inferior lower court like a Court of Appeals or a U.S. District Court, to make a determination. So I would agree that this case would have been ripe to hear. But I think that if he was going to rule in favor of the student, that would have been overturning, 40 years of precedent.
And also speak to the larger thing that's going on here, too, the U.S. cultural wars here with the new administration that's coming in. Since returning, President Trump has taken a hardline stance on gender ideology here. So you're seeing the Supreme Court kind of move along that tack with a conservative leaning 6-3 majority of the court.
And I think that would have also been one of the reasons why the court probably didn't want to touch this, is because they want to avoid those political question type of cases where are we doing things that spark or further divide the country politically. And oftentimes the court wants to avoid those, and they want to stick with the types of questions that are, is it a question of constitutional issues? Is it a question of a deferring or divisive 2 different courts that are not going in the same direction? But in situations where you have clear guidance, where you have things that have been ruled consistently for the years, you don't want them in interjecting any political sensitivity of the time, because then what you have is a ruling that's inconsistent with what precedent is.
All right, that's going to wrap it up for this one on this subject right here, for talking about the T-shirts and gender ideology, U.S. Supreme Court. And we're going to take a short break here on Queen City News Plus. But when we come back, we're going to be talking about a couple of cases involving pregnancy. One, a case out of Minnesota involving a major corporation, and another case out of New Jersey. And stay right there with Queen City News Plus. We'll be right back. All right, welcome back to Queen City News Plus. Brian Blakely here with Chief Legal Analyst Khalif Rhodes. And our next topic we're going to be talking about is a couple of cases that are kind of intertwined. A couple of ladies are saying that they were fired because they were pregnant, is what the legal challenge is here. One with in Minnesota by a corporation, big corporation, 3M. The woman says that she was
love
fired.
their stickers and all the other things they use, right? But sorry, go ahead, Brian.
No, that was it. The other was out of a case of New Jersey. But let's start with this case out of Minnesota right now with 3M.
Well, what I can tell you is both of them are really weird in terms of timing, right? And so the one woman was fired right when she was coming back after having the baby. The other one was fired right when she was about to leave, about to have the child. And so those are the types of things where I can first say I take personal issue with, because as a father of 4, I work with my wife, who is an attorney. We went to law school together. I remember the process of her being pregnant, lugging her bag out the door to go to work, parking, walking across the street. She worked all the way up with one of our children to the day that she had the baby. Like, she worked on that Friday. My daughter was born on that Saturday. And so I couldn't even imagine, like, you giving your blood, sweat, and tears to a job, And then they have the audacity to try to say, oh, yeah, we're going to terminate you for something other than performance. And I mean, yeah, we're two guys sitting here trying to talk about it, right? Like, but at the end of the day, I can still empathize and understand how confusing it has to be as a woman that's worked their butt off to get to wherever they are to be terminated. And one lady, she was in HR. So, like, if you're going to fire anybody, don't fire the HR person. The lady that knows the manual, that knows that you can't fire me for this anyway. So
that's also a question, too, because you have a major corporation like 3M with lawyers that seemingly are endless right now. How could they not have seen or anticipated something like this and let this go through?
I can do one word for you, the middle. The middle. That's why. Because I'd say that all things rise and fall in leadership. That's John C. Maxwell. I didn't make that up. But the other thing that I recognize with corporations, and he recognizes that as well, is that while you're at the top, you have these lofty ideas of goals of things that you want the organization to do. But as they trickle down to the bottom, like on the ground, the folks that are actually making the stickers and making their all the products that 3M makes, somewhere in the middle is that middle management. And that's where folks are lost. Things are lost in translation, and things are often lost in ideology, like who we are as a company. So 3M at the top probably didn't recognize that this was even happening. And so then when they recognized it was happening, they already got smacked with a lawsuit. And that's when you grow too big to fail, things like this kind of fall under the radar. I mean, but you think from a 50-foot view reading of both of these cases, I don't understand how they would have thought you could fire them. I mean, you got so many protections. You got the Pregnancy with Discrimination Act. You got the ADA. You got the FMLA. You got all kind of things that are in place to protect women specifically in these situations. I mean, and it's like you can't make it up. Like the one was clearly about to leave to have the child. The other one left and was already on leave and came back. So those are about to come back. Those are the types of things where it's like, read the room. Like, make sure that you're recognizing that they have heightened protections. I said this before in the past. Federal employees are probably the most protected, used to be the most protected folks that fire in the country, right? In the current administration, maybe not as much protection, but used to be the most protected folks to fire in the country. Right behind them is any pregnant woman in any position. Union job, non-union job.
There's not a lot of sympathy when you see this type of case come up.
It's not. I mean, and I am. If I have an opportunity to be in a case like this as a juror, I'm looking at the company like, how dare you fire this person that's trying to work, do their job, show up every day, and now you're saying you're not good enough, and not based on performance. Let's make it clear. You didn't put it on performance. You said that they were just being let go for reduction in workforce, that they were just being terminated. Those are the types of things, as a former union organizer, I also take issue with, because you have labor protection rights. In a state where you have those protections, they just can't fire you because they want to. Your union rep would step up and say, hey, hold on, this doesn't seem like it passed the smell test. Let's figure out if you went through the protocols. Were they on some performance improvement plan? Were there things in place to ensure this person was, rightfully had an opportunity to protect their job? And it seems like none of that stuff happened. So now what do we have? Money, because now lawyers are going to have to get involved, and both sides are going to have to pay.
Yeah, and the judge in that the ruling of former Minnesota Supreme Court Justice said the reasonable juror could determine that the timing of her pregnancy and maternity leave, when the company needed to reduce her 5-person unit by one person, was a motivating factor in the decision in her position. But so she saw that right away. But also, this is one I do like, and you just kind of spoke to this a short time ago. The lawyer representing, which you love to have taken this case, Paul Dworak, representing the lady in this case, said a statement that was heading to a jury. No mother should be forced out of her job at the 8th month of her pregnancy merely because it's convenient for an employer. Working mothers deserve to spend their child's first months focusing on bonding and caregiving, not on job hunting.
Brian, I can say this. There are some cases that walk through the door and you're like, wow, that is the one, right? This would be the one. Because you're like, if I put this in front of a jury, if I first of all, I'm sending a demand letter, and the very thing I'm saying when I send this to 3M is, these are the facts, this is what we're demanding, settle or we're going to trial. And the second they refuse to settle and give payback or back pay, pay back any type of future earnings, put her right back in her position, all those types of things, pain and suffering, we need all that money. If you're rejecting any of those things that we're asking for, we're going to trial. And I put this in front of a box of 12, and those people are saying, they listen to these facts? Did this lady's carried this baby to 8 months? She's about to leave, and you're telling me you're going to terminate her? there ain't going to be a dry eye in that jury box. So good luck with, winning this case. I don't care what the facts are. I remember meeting an attorney in Mecklenburg County here in Charlotte, and they were saying his client was dead to rights. The DA's office had him, and they were like, well, you don't know this attorney because he doesn't really care about the facts. He's really good at making sure he paints an excellent picture. So if I took that case, it's the same way. I don't care what the facts are. All I got to be able to do is put this woman up there, put her maternity pictures up there, put her baby pictures up there. I don't really have to say anything else. The case is pretty much over. The case will speak for itself, that the folks in that box, and all it is one mother in the jury pool, she's going to say, that could have been me. Yeah. So those are the types of things that touch on a person's heartstrings. I mean, in news, we do it all the time, looking for that personal story.
When I'm picking the emotional angle out of that to get to people, in addition to the facts in our business.
I'm looking for that in the jury as well. I'm looking for a person that's sympathetic, that wants to hear, but also can make a real life connection to that person. And so what better way to make a connection to that person than if you've been a mother yourself, if you've carried a child, if you've had a job, if you work while you're pregnant. Those are the questions I'm asking. Well, have any of you guys worked? Okay, the folks that raise their hand, yeah, I'm probably keeping them. All right, have you had a baby before? Yeah, I'm probably keeping them. And then I need the other side to try to figure out a way to get rid of those individuals, because if they can, not automatically will they rule in my favor, but I think they at least hear. And that's all you want.
Also, the other thing, too, is that here is a couple of mothers who did stand up for themselves and get a lawyer to do that. There's a lot of people who will probably out there and say they would not try to go attack the company or try to go fight for themselves to find what their rights are after something like this. So this speaks to them to say, hey, somebody is out there, they can fight for me, and it can be heard, the case.
Oftentimes, things in the legal system are not cheap. So we got to start there. Every time a client comes to my office and talks about wanting to file a lawsuit, I tell them litigation is expensive. It's not cheap. And because litigation has unending, never-ending, like blank check movie style, when you got that blank check.
In some cases, it's just a percentage on the back end or whatever.
It depends.
On the settlement.
It depends. And so if you're taking a case on contingency,
33 and a third or whatever, 40%.
If you're taking a case on contingency, yes, then the law firm will eat all of the costs up front and then have to, be recouped on the back end. But sometimes it doesn't work like that. Like in a workers' compensation claim, a lot of firms won't handle it on a contingency. Sometimes they'll handle it on a flat fee. Like you'll pay this amount or you'll pay a retained amount. So, hey, I don't know how much it'll cost you, but I'm going to need you to put $10,000, $15,000 in a retainer, and we'll bill from that. And then once we exhaust all those funds, you'll have to recoup reinforce that retained amount. Those are the types of things that happen when we talk about an unlimited cost, but it's case by case. Typically at workers' comp, they're not taking it on contingency. They're saying, we're going to take it, and you're going to have to pay for this litigation and potentially not get attorney fees on the back end. And so when you talk about the cost of justice, sometimes the cost of justice is too heavy for a person to be able to bear because you don't have the resources to be able to cover what it would cover to get equal justice.
Yeah, all right. Yeah, we're going to leave that one there right now and certainly keep covering that if we can. But for now, we'll take a short break here on Queen City News Plus with Brian Blakely and Khalif Rhodes. And coming up after the break, we're going to be talking about some Trump tariffs, specifically how states are handling some of those tariffs and the court decisions that are going on with that. We'll be right back. All right, welcome back to Queen City News Plus. Brian Blakely along with Chief Legal Analyst Khalif Rhodes. Khalif, we're talking about Trump tariffs, and the U.S. judge here dismissed a California challenge to the President Trump's tariffs, allowing the state to file an appeal over the court's ruling to dispute what was filed on that it should have been in U.S. trade court in New York. So a lot of these legalities here are playing out for the Trump tariffs, and basically because it's such a roller coaster back and forth when it happens, and a lot of these states are being hurt.
It's a roller coaster ride. I mean, but at the end of the day, the Trump tariffs, you knew that this was something that was going to occur. President Trump was trying to be, to shake up the room, to be spontaneous with his approach. He made a couple of promises during the campaign, specifically that if I'm going to make America great again, I got to get rid of folks that are coming to the country, immigrants, and also got to find ways to bring back jobs to America. His approach with bringing back jobs to America is to put the pressure on other companies. Either you will have tariffs when you import stuff that you make out of another country, or you'll come here and have plants here in this country and make it here. I mean, it seems like a good strategy. The only thing is who gets hurt in the middle is the American people that have to pay the higher prices on those tariffs. And so while we get there, and he's already admitted that during some of this part, it will be a tougher road to hoe for some folks, but in the end, it will, get to the end result that he's hoping for. In terms of the court process, I mean, these are typical rulings that you're going to have one side that wants to have it go their way. You're going to have an opportunity to appeal, and you'll have the courts make a determination on whose side's right.
Yeah, consumers are going to have to feel some pain out of this. But the Trump, he cited to justify the tariffs here as the International Emergency Economic Powers Act. But it does not authorize tariffs at all, so it cannot be forced California to litigate the trade court. That's according to California's Attorney General Rob Bonta said in that, it's kind of whipsawed everybody here back and forth on these tariffs because it's not an easy thing to undo your supply chain, your suppliers, and when you're trying to get in, and change up some of the things to not pay as much in the tariffs and try to work around this stuff.
We've had a couple courts talk about this Emergency Powers Act, too, and so I want to make sure we're clear on that. What the Trump administration is attempting to do is say that because we have this trade deficit, that I can say that this now is an emergency. The only issue with that, and this is what most of the states, 16 that have joined that lawsuit that you're mentioning, and a couple individuals, specifically wine company and wine manufacturers in California, they're saying that this emergency has been in place for the last 49 years. So if it was an emergency for the last 49, how come now it has to be an emergency? Like, this deficit wasn't something that popped up today, didn't pop up last year, didn't pop up last administration. You're talking about 49 years of a deficit. So you can't claim that to be the emergency. That's what the courts have ruled a number of times so far. I think attempting to go forward and figure out how we move with these types of tariffs, he won't be able to use the economic powers. The emergency powers. He'll have to utilize any of these other things that are at his discretion. And the courts have told him that you have discretion to do that. You just can't use it on an emergency basis. And the other thing the courts have told him is that if you really want to do this, just go to Congress. Congress can give you the authorization to do exactly what you're asking, and you have the votes. And so I think the president just doesn't want to, A, follow what the courts are telling him to do, but B, doesn't want to have to go to Congress asking for anything. He's like, if I want to stand here and I want to show you what these tariffs are going to be, and I'm going to be able to do it, I'm going to implement them, and you're not going to be able to tell me that I can't. And the courts have empowered him to some degree because even though he implemented these tariffs and we think that they're one sweeping tariff, is multiple laws that he's using to implement them. So the court said, look, 2 of them, you're allowed to use them. Matter of fact, we encourage you to do it like that. Just attempting to do it under this emergency act, can't do it, shouldn't do it, and not authorized constitutionally to do it.
Yeah, and one of the things that the states argue is that some of these states are being hit harder by the tariffs because you have a lot of these imports that are coming into California, and California feels like they're being singled out.
Well, and I'd say rightfully so. Anybody that's on a port, anybody that has a sanctuary city, anyone that's not complying with the Trump administration's approach to immigration, you will be finding yourself in the crosshairs. And so if it happens that now you also will be a place that has an economic impact negatively affected by these tariffs, I don't think the Trump administration is running to try to find a way to put the fire out with your increasing costs, because you're not running as a state to try to help them with the immigration efforts. They already just had a list that they pulled back down off the website that talked about having the states that were not supporting the Trump administration's approach to immigration. If you line those 2 up, most of those are states that are on the borders that have a heavy influx of immigrants and a heavy influx of imports. So what I can tell you is the Trump administration is trying to find ways to ensure that you're in compliance with what this administration is attempting to do.
Yeah, and we've seen a lot of companies try to work around the tariffs and do whether they're bringing in a lot of imports right now before the tariffs have taken effect. So they don't have to pass on the cost to consumers. And a lot of companies are already passing off the cost to consumers. And they're the ones who are going to be paying the price of this. When you're talking about even companies like Walmart, where you get a lot of imports from overseas,
right?
They're already going to pass the cost on to the consumer. And we're the ones who are going to have to be paying.
Yeah, I saw that message from Walmart the other day. They sent it out saying, and obviously these folks are having to disclose a lot of these things in their finance reports, right? So they're publicly traded companies. So they're going to have to disclose the impact that's negatively coming from these tariffs and how it's going to trickle down to their customers. Walmart said, we've tried for a long time to keep our costs down, but at some point we're going to have to defer it to the consumer. Trump came back and said, well, hey, you guys have had record profits. You'll have to eat that cost. Again, back to his negotiation strategy, and it's that I want you to do what I'm asking you to do, or I should say telling you to do. And if you don't, you'll have to figure out and deal with the
But wait a minute, but
consequences.
doesn't that attack free market capitalism right there?
You
You
would
made too
think-
much money.
You would think that it would in a capitalistic economy that getting money is supposed to be like the benefit of being in a capitalist society, not a socialism. But what Trump is saying is that you've already had record profits. Don't pass it off to the consumer. Why? Because that's his base. If I'm telling these consumers that are there, that are shopping in these locations, that are out there trying to spend money, that I'm going to bring back jobs, that I'm going to lower costs, I can't on the one hand have these companies now raising costs because it won't help them. We were talking about the price of eggs during the Biden administration, if now the price of everything goes up, then he'll be the blame for that. And that what I can tell you is, like him or love him, he understands the temperature and the pulse of the American people. And so if you're saying that, look, I don't want to see a cost increase on my everyday goods, he's going to attack a company like Walmart instantly that's trying to defer costs. And I think this tariffs thing is not over. Outside of the fights that they are having within the court systems, the tariffs are still battling within these other countries. America and China, you have them just still going back and forth on, do we have a I should say a ceasefire, but a temporary pause on what these tariffs will look like. But I think as we figure out how the courts allow him to implement that, I think the president still wants to have at his disposal the ability to levy tariffs against any company in any capacity of the country.
And the European Union,
right?
Because those are the ones that are hitting right now. So
right.
You have to worry about those over the summer months.
His goal is to be able to have the ability to utilize it at his disclosure. And I think stepping back and listening to a number of things what the Trump administration does, it has the approach of a company, right? You have a CEO, and whatever the CEO says is gold. Attempting to utilize that same strategy in a democracy, specifically from the executive branch, is a little bit harder because you have a lot of these things put in place by our founders to avoid that from happening. So that's really what we're running into. And it doesn't really matter what the title, if we're talking about tariffs, if we're talking about immigration, if we're talking about gun control, if we're talking about, cutting Medicare and Medicaid, whatever those issues are, the easy way to do it in a company would be, hey, the CEO signed it, it's done. But it's not as easy in a democracy where you have to have bipartisan support, where you have to have the other two or three, those two co-equal branches of government supporting and working with you. And so right now, I think that's where we're running into the biggest issue. And these tariffs are just another rendition of what we've seen before.
It is keeping a lot of lawyers busy right now for sure. And also consumers worried about some of the prices going forward as well. All right, that's going to do it here for us on Order in the Court. Chief Legal Analyst Khalif Rhodes and myself, Brian Blakely. Thanks for watching Order in the Court and Queen City News Plus.
Queen City News Plus. Just search Queen City News on your smart TV's app store.